What's up, Colorado Realtors? I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. I got to apologize to you guys. It's been kind of a 2-month break between the last Legal Bites and this Legal Bites. I'm going to knock out 3 of them in a row today, so don't think I just wear the same suit all the time. But we'll release the next 3 over the course of the next 5 or 6 weeks in a series. And so I'm sorry, I've just been busy, go figure, and haven't had a chance to get back here in the studio to do some of these. So thanks for your patience on this. On this edition of Legal Bites, we're going to be talking about the relatively new now, personal property agreement. This was effective and for broker use, promulgated by the Colorado Real Estate Commission effective January 1st of this year. So it's been floating out around there for a few months, and I've had a ton of questions about it on the hotline and elsewhere. It doesn't need to be a terribly confusing document, but let me give you a little bit of background on it. The reason this form was developed was to address concerns related to loan fraud. That was the primary reason it was pushed out there. And what would happen, particularly since the mortgage crisis, where the underwriters have been a little bit more, let's say, scrutinizing of contracts on loans that they're underwriting for real estate, brokers send over a contract and it's got a list of inclusions. And primarily this is most applicable and I think will be utilized most in resort communities where condominiums and such might be sold fully furnished. And so there's a whole bunch of personal property involved in the transaction. But even in smaller situations, occasionally, the parties will list out in the contract that the seller is going to convey to the buyer a list of personal property items. And then that contract goes to the buyer's lender. The buyer's lender gets it, and what do they say? They say, get it out of the contract. We don't want to see it. And that will engage the parties then, and often the buyer, to go and try and do a side agreement or a handshake deal or some other what is an illegal side agreement that becomes not disclosed to the lender, which is the definition really of loan fraud. And so the hope now is that with this personal property agreement in the contract, there's a new box at the very bottom of, I think, page 1, or maybe it's the top of page 2, but it's right in that personal property section, that the parties can check and say, hey, there is a separate agreement for the conveyance of personal property. It's not part of this agreement, but there is a separate agreement. So the agreement itself is disclosed to a buyer's lender, and then it takes it out of the loan fraud concerns, because it's not an illegal or undisclosed side agreement to the lender. And so that's really the purpose of it. When to use it, again, I think this is in a situation where there's a lot of personal property being conveyed. It shouldn't be used, or it shouldn't need to be used in most cases for conveying, the household appliances, the fridge and the dishwasher, washer and dryer, the common stuff. If you've been listing that in the personal property inclusions on behalf of your buyers, and that's been working with their lenders, then don't use this personal property agreement. It's not necessary there. It really is more confined to a situation where there's a more explicit enumeration of personal property items that are going to be conveyed, right? So don't overcomplicate the transaction. If it doesn't need to be used and it's okay with the buyer's lender to just list the certain limited items in the contract itself, then keep listing it in the contract itself. That's totally fine. It's only in a situation where they might say, get it out of the contract or take it out of the contract. So I mentioned before, it is not part of the real estate contract. It's specifically designated as a personal property agreement. It's a standalone contract that refers to the real estate contract, but it's not a part of. So it's not an addendum, it's not an attachment. There's been a lot of misconceptions about those 2 items. It also contemplates that there will be some consideration given that's fair market value. And the fair market value, it's got to pass a sniff test. I mean, there should be some value to that. If it doesn't have any value, if the property doesn't have any value, or it's truly being left for the convenience of the seller, then don't do an agreement. If it's there when the buyer shows up, it ought to be, because if it was truly for the convenience of the seller, then the seller would not take it. I mean, if the buyer wants to say, hey, leave what you want, or that's great if you want to leave it, or take what you want, then there's no agreement there, right? That's just an expression of something that truly might be of zero value, or truly might be for the seller's convenience, which is, I know, language that you guys like to use a lot. But if there is going to be value, if there is a fair market value, then the parties are responsible for determining what that fair market value is. And my biggest concern with this thing is that you guys as realtors get involved with trying to price or value for your clients what, hot tubs or flat screen TVs or pool tables or pick your personal property that might get included and trying to assign a value to that. That's not what you're engaged to do. You're real property experts, not personal property experts. So don't let your clients suck you into that. There's also another area that I get questions about, and that's the UCC search. The UCC search is, I like to, it's analogous really to the clerk and recorder's office where real property information and encumbrances might be recorded against a piece of real property. The Uniform Commercial Code, which you can find information, would be recorded against personal property, and you'd identify those recordings or encumbrances on any personal property through the Secretary of State's office. And so something, again, it's easy to do. Your clients can go and your buyer can go and determine if the seller has any encumbrances on any personal property that they might be intending to include as part of the real property conveyance. And so that's another area. Don't stress out about this, about these new forms. I mean, again, if you don't need to use it, you don't need to use it. You don't need to use it for your fridge and your washer dryer or your hot tubs, even in the event that the lenders don't have a problem with that kind of more common stuff being enumerated in the contract itself. If it can be put there, put it there. And in the event that they say, hey, get all this stuff out of there, then you can use the form. And in the event that the property doesn't have value, then don't worry about using a form. Just let it be truly for the seller's convenience and allow the buyer to tell them, leave what you want, take what you want. And so don't stress out about the new form, but I do think it's a good tool for the parties to use to avoid getting into to avoid getting into a loan fraud situation. So use it when it's necessary and use it at the party's instruction, but hopefully that gives you a little bit more perspective and background on the reason for the form and maybe calms a little bit of the stress that's, I know, been floating around out there since this document's been introduced. We've got some events coming up here, and I'll let you guys look at that. I won't get into reading those, but love to see it at our state and national events. It's always great to see our members. And as always, if you guys have questions about the personal property agreement or anything else like that, the Car Legal Hotline is available from 9 to 12 and 1 to 4, Mondays through Fridays. Love to hear from you there as well. So thanks for tuning in, and we'll see you on the next edition of Legal Bites.